Similarly, promotions is also an area where you can have ADEA claims. So, a couple things we would want to look at to see if this was potentially an age-based decision. Is there a bona fide seniority promotion system in place? Is the employer following it consistently? That would be good support for the employer, even if they give the promotion to someone younger if they met the criteria for the promotion, or even if they had more seniority than the older person. The fact that you're older doesn't necessarily mean you've been at that company longer than someone who is younger. So that would be the first thing we want to look at. We would also want to look at the objective job descriptions of the positions, and the appropriate employee evaluations. How was the employee's work up until that point? Were they qualified for the promotion? Uh, were there any red flags? Were there issues why they didn't get the promotion? So you can definitely have an ADEA claim on a promotion situation. But again, we would just need to get more information to see if age was a factor or if there was legitimate bona fide reasons that the employee did not get the promotion and someone else who was qualified for it did in fact get it. The next section is the ADEA and benefits. So generally speaking, whatever benefits an employer offers, they need to offer to all employees. So whether that's medical insurance, retirement benefits, time off, that type of thing. Obviously, in union situations, certain things will be negotiated on behalf of the union that might be a little bit different in terms of management. So you might have some situations where there are some differences where it is appropriate, but generally the rule is the employer needs to be consistent in the benefits that they are offering. There is one area where you might see some difference and it might be deemed to be okay. That is called the equal cost defense. And this applies in life insurance, medical insurance, and disability insurance situations where the employer can provide less um, less benefits, so to speak, to older employees if they are in fact spending the same amount of money in cost on the employee. So an example for that, and they give an example in the textbook, um, the employer is going to spend X amount of money on life insurance for all its employees. For younger employees, that amount of money will pay for $50,000 in life insurance benefits. For older employees, that same amount of money will only provide for $40,000 in life insurance benefits. So the money the employer is paying is the same for all employees. It's just the benefit itself is a little bit different based on age. And so in some cases, this equal cost defense has been successful because the employer itself is not treating the employees differently. They're providing the same resources, so to speak, the same money to fund these benefits. It's just that the money buys a different level of benefit. So you might be able to assist an employer using that defense if somebody were to bring an ADEA claim. But again, generally, same benefits across the board are required. Another area where we sometimes have ADEA issues is with retirement. So first off, mandatory retirement ages are prohibited under the ADEA. Okay, so this means that most employers, especially private employers, they cannot impose a mandatory retirement age. They cannot tell employees when you hit 65, 70, 75, you must retire. And that is a big misconception that a lot of people have. A lot of people think that that is appropriate and allowed, and generally speaking, it is not. Now, there are some exceptions to that. Firefighters and law enforcement are two areas where you can have mandatory retirement ages. Airline pilots is another area where there are mandatory retirement ages. And so with those, you can definitely see a potential safety reason for it. And then highly compensated executives and policymakers. So if it's not dogs, it's phones. Hopefully things will be quiet for a while and let me get through this. So again, my apologies. Not even exactly sure where I left off. I think I was talking about the fact that um, a lot of times people think mandatory retirement ages are kind of across the board acceptable, and they absolutely are not. Employers have to be very, very careful about that. What you might find is having some cases walking through your firm's doors where you have an older employee who feels like they've been pushed out, because you do sometimes see that. It's not, I'm going to fire you because you're older, or I'm forcing you to retire, but I'm just going to change the terms of your job a little bit to make it a little less pleasant and hope that you will eventually retire. And those can be very tricky cases, but those might be ADEA claims as well. And so, if somebody is um, still qualified to do the job, still doing a good job, then they may have an ADEA claim if they are in fact terminated. It can be tricky for employers though, because sometimes you do get people who are still good at their job, but maybe not as effective as they used to be, but not necessarily bad enough to justify firing them. And sometimes employers will start to feel very stuck in that situation, even though it's employment at will. They are concerned that if they fire someone, it will be an ADEA claim, and they're not necessarily convinced they have enough information or support for a non-age based reason to get rid of them. And so it can be a tough situation for both employees and employers. And I know I've worked places where you looked at some people and you were like, yeah, I think they're ready to retire. They weren't really ready themselves, but were they doing the job as well as other people or as well as they used to? Probably not. But were they doing a bad job? No. So it can be a really tricky situation. So employers just have to be very, very careful how they deal with that. One thing that is allowed under the ADEA is early retirement incentives. And so this is when the employer basically puts out an offer to all qualified employees to retire at this certain point in time, and in doing so, receive certain benefits that they wouldn't otherwise receive. These early retirement incentives are allowed under the ADEA, even though they do, in fact, disproportionately affect older workers, because for the most part, people who are qualified to retire are going to be 40 years and older. And whether they're qualified to retire, it depends on what the employer's policies are. Most employers will have written policies that after 20 years of service, 30 years of service, or something like that, you are eligible for retirement and retirement benefits, and it'll list what those benefits are. Early retirement benefits are for people who meet the retirement qualifications but aren't yet otherwise planning on retiring. And so there's an incentive to retire. And so sometimes it's a cash incentive. Sometimes it's continuation of health care benefits for a certain amount of time after they retire. It can be all sorts of things. The most important factor with early retirement incentives from the employer's perspective is that the employees have to actually make a voluntary decision, meaning the employer puts the offer out there and it is up to the employees whether to accept or not. The employer cannot coax them, cannot advise them to take it. Even if the employer, or say a manager, is trying to be helpful to an employee and it's like, hey, I think you better take it because if you don't take it, I think your position's being eliminated. That's like a helpful piece of information. But then when that employee turns around and accepts the retirement incentive, it's not truly voluntary because they felt they had to take it because they were going to lose their job anyway. So it's a really kind of strange situation where you could have someone trying to be helpful to an employee and advise them to take it, knowing that if they don't, they may lose their job anyway. So you might as well retire and get the benefit of this early retirement incentive. But by doing so, that actually makes it not voluntary, and that is problematic. And it's a weird kind of thing where you can have good intentions but still be a violation of the ADEA. With early retirement incentives, The employer must also comply with the Older Workers Benefit Protection Act. And I don't require you to remember the name of this particular act. ADEA, yes, you need to know that. Older Workers Benefit Protection Act, you don't. However, you need to know generally what this act means. And they talk about it in the textbook. This is the act that ensures the acceptance of an early retirement incentive is truly voluntary. So basically, it has requirements that that this information has to be put in writing, that the early retirement incentive has to specifically reference the ADEA, that there is consideration, meaning if you retire early, you will get this benefit. So you have that exchange of benefits and detriments. There's also a really important time frame component to it, which again, you don't have to remember these particular time frames, but the employee has to be given at least 21 days to review before they accept. Longer if it's a group layoff situation, that can go up to 45 days. And they actually have a 7-day period to revoke, which is very unusual under the law. We don't generally have these built-in revocation periods. But this is really to ensure that when an employee is making this type of decision to accept an early retirement incentive, that they are making it voluntarily and that they have time to think about it, that they are given all the appropriate information, and that even once they make the decision, they still have 7 days in which to change their mind. So in these cases, you have to comply with the ADEA as well as this act. And if you ever see one of these waivers that employees sign saying that they understand they have these rights and they're giving up all these rights to accept this retirement incentive, they're not just giving up their right to file an ADEA claim, they're giving up their right to file like every claim in the world. I've seen these waivers that people will sign and they're multiple pages long. So when an employer brings in an early retirement incentive offer to employees, part of the acceptance of that is that the employee is going to waive any age discrimination as well as other claims against the employer, and that's again part of the consideration. But the key word, voluntary. They have to be voluntary as well as comply with all these particular laws. And then the last section we're going to discuss is the reduction in force section. So reduction in force, RIF, sometimes it just gets referred to as RIF. So just be aware of that, is when the employer either just has a truly layoff situation and they lay off multiple employees, or they're just otherwise decreasing their number of employees with no intention of potentially calling them back. Sometimes being laid off, the intention is you will potentially be called back to work when the financial situation improves. Sometimes the situations are just we are downsizing and we have no intention of calling anybody back. Either one of those is a reduction in force case. These, again, a little tricky. They cannot target older employees. Yet, who are you more likely to get rid of when you are making a decision based on finances? You are likely to want to get rid of the people who have the larger salaries, who cost more in terms of benefits, whether it's the retirement contributions or health care or those types of things. So that's older employees, yet reduction in force cannot target older employees. And I'm going to end this one, and in the next one, we'll talk a little bit more about the reduction in force situation.